In the case of Iancu versus Brunetti, what's at issue is whether or not the Trademark Office should be required to register marks that are immoral or scandalous. That is, marks that might offend a substantial portion of the general population. The parties are Iancu, who is director of the Patent and Trademark Office, and Mr. Brunetti, who is the founder of a clothing company that sells high-end, modern, edgy streetwear under the brand name FUCT. Mr. Brunetti tried to register as a trademark the name of his company, FUCT, and the Trademark Office rejected his application as being immoral or scandalous under Section 2A of the Lanham Act. The Lanham Act was enacted back in the mid to late 1940s, and it basically covers trademark law. The provision of the Lanham Act that's at issue in this case is Section 2A, and specifically the immoral or scandalous clause. So the terms immoral and scandalous have generally been interpreted as being offensive to a substantial portion or a significant portion of the general population. So the usual uses of Section 2A, immoral and scandalous, are generally to deny registration of marks that are related to sex, drugs, or religion. The motive for denying registration of marks that are either disparaging, as in the Matal versus Tam case, or immoral or scandalous, as in the Brunetti case, is the idea that we want to protect the public from trademarks that might offend them. That's the reason that the constitutional issue comes forward, is protecting people from offensive speech. There are two types of discrimination that have been discussed with reference to this case. One is viewpoint discrimination, and the other is content discrimination. The idea of viewpoint discrimination is the idea that the message that is being prohibited, if it was a message to the contrary, would be permitted. The idea of content discrimination is that the speech that is being regulated purely based on the content for which it is being said. In the Matal case, the idea of viewpoint discrimination was on display because the Trademark Office refused to register the mark the slants because it was a derogatory term referring to the Asian population, while the Trademark Office was perfectly happy to register other trademarks that referred to Asians, such as celebration or the Asian efficiency. The best argument, I think, for Iancu in this case is the idea that this is different than Matal versus Tam. In Matal versus Tam, there was a very clear expressive component to the speech. The term was chosen by an Asian band to reclaim a term that had been used in a derogatory manner towards Asians. In this case, the term wasn't selected to try to reclaim a term that had otherwise been deemed derogatory. This instead is just a term that is generally viewed as vulgar or obscene. There's not the same idea that this is an expressive trademark that's really putting forth a viewpoint that needs to be heard. The government is arguing that there are a number of open questions left after the Matal versus Tam case, such as whether or not this is commercial speech and thus should be viewed with less strict scrutiny. That could help distinguish this case from Matal versus Tam. The best argument for Mr. Brunetti is simply this is Matal versus Tam. The provision in the Matal versus Tam case was disparaging, but the immoral and scandalous clause is in the same section of the Lanham Act and is also largely content-based. Even if it's not viewpoint discriminatory, it's content discriminatory. In fact, the discussion that was had by the trademark examiner in the T-tab is that Mr. Brunetti's mark was vulgar, that it referred to misogyny, that it was lewd. So they're clearly looking at the content of his proposed trademark to be registered, and with that, that's a regulation on free speech. And so I think Mr. Brunetti's best argument is that Matal versus Tam should be extended to also find unconstitutional the immoral and scandalous clause of the Trademark Act.